earlier in the inquiry, discussion of these matters is purely procedural and it doesn't alter the position taken by either the Rule 6 or by the Council in these discussions. Those matters aside, I'd like to start with the planning obligation side of the equation before we go on to the conditions. Before we get going on that, does any party want to raise anything before we dive into the document?
Can I just take a moment to just introduce somebody who hasn't been to the inquiry on our side? To my immediate right is Miss Jane Seymour, whose appendix you will have seen in Mr. Venning's evidence, and she is a viability expert, a chartered surveyor who worked at the council for 7 years. But in terms of the community action group's position, I just think it's worth just setting out so that we obviously haven't been involved in the detail of some of the negotiations that have been taking place between the council and the appellants. We've been kept abreast insofar as we are seen as part of that and as relevant to that. But I just thought that for us, once we get into this discussion, you'll find that there are issues that remain at large for our side that may not necessarily be at large for the council side. And so what we would ask you to do is keep that in mind throughout. And whilst as far as I'm aware, there's no mechanism that's being offered by the appellants to try and meet some of our concerns insofar as a sort of a blue pencil clause or whatever. We'll find out whether that's the reality or not in just a moment. But for our part, please don't sort of underestimate the extent to which there is a difference between us. Even if the council don't necessarily take that issue, we still do. And that will go through line by line as you go through the discussion.
Understood. Could I just check with you, Mr. Mohammed, have you seen the most up-to-date copy?
Yes, we have seen the most up-to-date version, and we've been spending a significant amount of time this morning discussing it. I understand that it may become a bilateral, but as things currently stand, it remains a unilateral document. And so we will have comments on, obviously, the issues that you've been discussing in the inquiry in relation to small shops, the displacement issue, and the viable relocation issue. That's one of the areas that we still have an issue with. And then Ms. Seymour will be speaking to you in relation to the review mechanism. And there are about 4 elements within the review mechanism that we have comments on. Some of that will align with what the council wants to say. Some of it is beyond that. And just for your note, I think a big part of our case also will rely upon taking you to the appeal decisions that my learned friend has been referring to, the Stag Brewery, the Cuba Street, and what was agreed in those. So we have the latest version. We're very grateful for that, but we have comments on it as well.
Okay, understood. I'd like to start, if I may, with seeking an overview from the appellant's side of the Section 106 agreement. I'm not sure who's going to take that.
Hello, sir. My name is Jamie Lockerbie. I'm a partner at Pinson Masons, and we're the planning solicitors for the appellant. So I, along with my colleague Suzanne Andreasen, have been leading on the 106 negotiations. So I'm happy to give you a sort of high-level summary of the document.
Yeah, if you could please. The main headlines in terms of what it secures, broad rationale for securing those, and then we can get into some of the details that are in dispute, perhaps with the Rule 6 and the areas of agreement with the council.
Yep, sure. Before I start going through the document, it's probably helpful to address the UU bilateral point in terms of the format. So you will have seen correspondence over the last few weeks from us and the council solicitors as to how negotiations are moved forward and timelines and things like that. Due to the move to a unilateral shortly before the inquiry opened, that's why the document is in that format. Shortly after the opening, there was a move between the appellant and the council to agree a list of blue pencil items. albeit the document was intended at that point to stay as a UU. There would be all the points of difference between us covered in this blue pencil schedule, and you would have seen that. The good news is, as the inquiry's moved on, the parties have managed to narrow down their issues of disagreement to, as far as I'm aware now, only one point as a blue pencil, which is the cycle hire docking station contribution and related definitions. So as far as we're concerned from the appellant side, the planning obligations in this deed are agreed between us and the council, save for that docking station contribution. And the council has agreed that they would be able to work with us to convert this into a bilateral deed. Ideally, I mean, from our perspective, we think we could do that before the closing session on the 17th of November. Happy to discuss details of a timetable on that, but that's our position. So this is, although it's currently in a UU format, we do believe it can convert to a bilateral. The council has said they would like to review the detail of the drafting on that, but the substance of the planning obligations, I think, are agreed.
Could you enlighten me, please, as to why it needs to be a bilateral as opposed to unilateral? I mean, perhaps in broad terms.
Yeah, I mean, obviously it's, I think primarily because in an ideal world, a Section 106 obligation would be bilateral, because obviously by signing up to it, the council is obviously agreeing to the planning obligations. And obviously obligations in an ideal world do function better where both parties can give and receive the covenants. In a UU situation, you've only got the appellant committing to do something on the basis that the council receives or uses monies and things like that on the basis they're specified in the document. So, I think, and hopefully the council would agree, in an ideal world, you would have a bilateral deed.
Has the bilateral request come from the council side?
It's been...
so it might be helpful if I address just where we are, because what Mr. Lockerbie said is not quite right from the council's perspective. So there has been a narrowing of differences. So the points that we're going to be addressing you on today are going to be more limited. But it's wrong to say that everything is agreed apart from the cycle docking. So just want to be absolutely clear on that from the outset, and we'll go through the issues as we discuss them today. In terms of whether it's bilateral, we remain content if we get to a position where there is an agreeable document to execute it as a bilateral. But as things stand at the moment, and we're happy to spend the time next week doing that work with the appellant if we need to, but as things stand at the moment, it is a unilateral that's before you. And it's not the council that's saying it needs to be a bilateral, it's the appellant's request that it should be a bilateral.
Do you agree, though, Mr. Tierney, it is a more secure provision if it is a bilateral?
It's not a more secure provision, sir.
In terms of spending financial sums?
So it's not. So the benefit of a bilateral, I think it's probably can be encapsulated like this. It can include particular obligations on the council in terms of the way in which those sums should be expended, and it can include dispute resolution provisions because those can only be entered into bilaterally. So you can't unilaterally impose a dispute resolution provision. And those things are normal features of bilateral agreements, and they're beneficial to both parties. So those sort of structural parts of the agreement would be better if they were bilateral. But at the moment, that's not where we are. I don't know. We'll explore today the extent of the difference. I don't know whether we can get to a position where there is a document that we can execute. If there is, then our preference would be it would be bilateral.
Okay, and could I ask Mr. Tierney, in a usual circumstance, would it be the council drafting a Section 106 rather than the appellants?
Absolutely, so we did draft the Section 106. We produced that document, I think, in April of this year, before the matter went to committee on the putative reasons for refusal. That was our document. It was provided to the appellant in April. We received the first set of comments at the end of August, and then there was a negotiation up until the middle of October, which broke down for reasons that we don't need to go into. That negotiation broke down. and then the unilateral undertaking was provided just before the start of the inquiry.
Okay, understood. Reference to the blue pencil clause. In the copy that I've got, I don't have an up-to-date blue pencil clause.
Yes, sir. So, well, if I can just say, in terms of what Mr. Turney said on the timeline, you have got all this in email correspondence. We had been progressing a bilateral very well up until the middle of October, but then unfortunately the council required to change position on a number of the planning obligations that we had believed were agreed, and so because of that, the appellant wasn't then the change in position was meant that the appellant couldn't sign up to those obligations, and so that's when we had to change to a unilateral undertaking, despite the fact that we'd had 4 or 5 weeks of very productive bilateral negotiations up to that point. And then obviously when we switched to UU, we have continued to proactively engage with the council, and we had thought we'd narrowed down the blue pencil issues, as I say, down to the cycle hire docking station. So if there are other points that are of the substance of the planning obligations that aren't agreed, this will be the first we're hearing about them today.
Okay, understood. Can we continue with an overview of what
Sure.
secures and what it doesn't, and where you are in terms of agreement?
Yeah, so as I say, sorry, I'm just repeating myself. When I go through the document now, from our perspective, other than cycle hire, we are believing this is agreed, but obviously we'll have to hear from the council in response. So the deed, you've got the deeds from the evening of Tuesday of this week, entitled Draft Planning Obligations, latest iteration, 4th of November 2025. It is, as Mr. Turney said, currently badged as a unilateral undertaking. There is a reference. There is a reference in clause clause 4, the appeal. You will see there at 4.2. So there's a 4.1. There's a general reference to your powers to determine whether or not a planning obligation meets the Reg 122 tests, and if you consider that it doesn't, were you to grant planning permission and you consider that it doesn't in your decision notice, then obviously you may say that a planning obligation doesn't meet the tests, and therefore under 4.1 of this deed it wouldn't have any effect. As we had, when we were under the belief that there were extensive blue pencil points between us, there was a schedule of blue pencil points in a table, and the idea with 4.2 was that each blue pencil reference in the document would be determined by you in accordance with the corresponding row of that table. The reason I don't propose to go into that in point by point detail is because, as I say, because we had thought the council had agreed to, as they narrow down all of those points to just the cycle hire docking, it becomes superfluous because the deed you're looking at now, we've each given on points, and therefore that table doesn't really carry relevance anymore, also I believe, coming into this session. But that is the answer to your question on the blue penciling. Our hope, if we can move to a bilateral, is that the cycle hire docking contribution would just be put into a standalone schedule in the document, and we will just say at the front end that schedule will either take effect or not as you decide were you to grant planning permission. So that's how I propose to deal with that matter if the obligations are in a position as I believe them to be.
And so it would be the inspector's decision text that would trigger that or not?
Just that, yes, exactly. So we will just tweak in what is hopefully the bilateral clause, somewhere in this clause 4 at the front end, that particular schedule that deals with cycle hire either takes effect or doesn't as you decide.
Understood, thank you.
So then the front end of the deed is largely fairly familiar boilerplate matters. I don't propose to go through those unless you have any particular questions on front end matters. I'm happy to answer those.
No.
Okay. So then we move to the substance of the planning obligations, which start as a Schedule 1 on page 42 of the document. You have Part 1. So I should say, by the way, the deed is structured as planning obligations relating to phase 1 and phase 2 of the development. So we will go through the parts in phase 1. Many of those are replicated in phase 2. There are some distinct matters that relate only to phase 1 or phase 2, and we can talk about those. So part 1 there, you have the financial contributions that relate to phase 1. Broadly, those are a mix of matters that are required to have financial mitigation as per the council's planning obligations SPD, and a mix of monitoring fairly standard council monitoring type costs. Part 2 is then we have affordable housing for phase 1, which is the social rented homes. And then there's the usual types of provision regarding affordable housing that you would expect to see in a Section 106 agreement. Again, happy to take any questions on those if you have them. Part 3 then deals with viability reviews for phase 1. And that is a what we call, and you may well be familiar, the delay commencement or early stage review. So if the appellant doesn't meet capital S, capital I, substantial implementation by the substantial implementation target date, then a viability review is required to be undertaken.
And that's a standard clause across London.
Yes, it is indeed so. Yeah. And then we have in part 2 of part 3, the mid-stage review, which is a mandatory review which will take place at 75% occupations of phase 1. And then obviously there's standard viability review drafting that you see in London schemes in both of those viability review provisions. Again, either myself or Mr. Levine can answer any questions on those if you have them. Part 4 is securing the delivery of wheelchair housing, phase 1. Part 5.
The wheelchair housing.
Yes.
There's no duplication with the building regulations in this.
No, this is to ensure delivery of those units. The specifications by which they'll be delivered will be by reference to the building reg standards for wheelchair housing.
Okay, understood. Yeah.
Part 5 is to ensure delivery of commercial floor space in phase 1 to Shell and Core prior to occupation of 25% of the market housing units in phase 1. Part 6 is ensuring the delivery of the public realm and ensuring public access to that public realm. Part 7 deals with transport and connectivity issues. There are standard provisions in there for parking permit restrictions, which I'm sure you'll be familiar with. There is then some bespoke drafting on the bus improvement works scheme. And I believe TfL might be here to speak on that in due course. But fundamentally, the way it works is in part 1, there's a requirement for the appellant to submit and have approved a scheme for improvement to the bus station. And there's a framework for the bus improvement scheme works attached to this 106 agreement. The appellant is then also securing safeguarding land for delivery of a route through the Clifton estate, should the majority of the residents in that estate wish for that to happen. And then you'll see there, sir, in paragraphs 4 and 5, reference to cycle hire scheme and e-bike and e-scooter storage. Those 2 paragraphs are linked to the matter between us in terms of cycle hire contribution. So in the event things transpire as I hope they will, those 2 paragraphs would move into the schedule that I referred to at the start, which will or won't take effect depending on your decision. We then have part 8, which is construction, employment training, apprenticeships and local procurement. So this is standard Southwark planning obligations drafting to ensure local employment targets and percentage share of construction costs to local supply chains. Part 9, we then have a requirement for an estate management plan. And then part 10 deals with habitat management and monitoring plan, which will essentially secure the legal requirement for the 10% biodiversity net gain requirement. Part 11 is standard London-wide carbon targets, so energy sustainability, potential for connection to district heat network, and then energy monitoring requirements, as I say, all standard drafting you see across London. And the annex is the carbon targets reporting. And that takes us to the end of phase 1. Happy to move on to phase 2 unless there's any questions, Ewan.
I'm going to turn to the Rule 6 in the council just to see if they've got any comments. If the council go first, yeah.
Okay, so I don't know whether do you want us to pick up points about drafting and legal enforceability as well, just to flag those for you?
If you could, yeah.
Yeah, I'll ask Mr. Arnott, Paul Arnott from Town Legal, who's been dealing with this along with his colleague Sadia Hussain, who's to his left, to just pick up those points, and then I'll touch on any points of substance.
Yes, good morning, sir. It's Paul Arnott, partner from Town Legal, instructed by the council in relation to Section 106 matters. So I won't obviously detain people too long, but obviously the document obligation that's before you at the moment is a unilateral, and there will be a drafting review to go through if it was to be converted into a bilateral, which is obviously the council's indicated that they're willing to continue to negotiate in respect of. I think what jumped out to me from the boilerplate provisions at the moment is the insertion of a dispute resolution mechanism. So this is clause 16 at the moment, which is entitled Council's Failure to Respond and Determination of Disputes. And I mean, the short point on that is that, as Mr. Turney has already mentioned, that when it's a unilateral obligation, that there cannot and should not be a dispute resolution provision imposing obligations on the council, because it's a unilateral obligation.
Do you see any reason why it couldn't be a bilateral?
Well, as I say, at the moment, what's before you is a unilateral, and as Mr. Turney said, that there has been discussions and movement on principles, but there remain a number of points, and again, we can touch on this in the drafting, where if this was to be a bilateral, then there would need to be amendments to the drafting. For example, and we'll get into the detail, there's numerous references to the appellant using reasonable endeavours to do various things, and apparently, as drafted, there's an absence of sufficient mechanisms for the council to satisfy itself that, for example, the appellant has discharged that. So, as I say, I make the point at the moment that unilaterals before you with a dispute resolution provision, which cannot and should not be in a unilateral. And obviously, it's unhelpful that the blue pencil schedule, which was referenced in here, is not before you today in the round table. So that was the sort of primary point in terms of the boilerplate provisions. Again, I'm conscious of time, so do you want me to? I mean, again, in the process of further negotiating this, which again the council is willing to do, we will look at the drafting. But again, I'm conscious of time with that. But that was the one that jumped out to me from the boilerplate in terms.
Yeah, that's helpful. I don't want to get into detailed drafting provisions. So yeah, it is the broad elements and to allow me to understand that I want to focus on.
Thank you, sir. Can I just pick up one point of sort of disagreement in respect of the affordable housing provisions? And this is a point that's been to and fro with the appellant on a number of occasions, but our view is that when you get to the provisions which appear in both schedules for obvious reasons because they apply to both parts, when you get to the review provisions, viability review provisions, what we would expect and see is that those who are supplying the information to inform that from the developer's side assume a specific duty of care to the council in respect of the accuracy of that information. And the reason for that is that having those sorts of provisions then can reduce the need for the corroboration of that information to be carried out at that review stage, because whoever's volunteering the information, whether it's Mr. Levine or somebody else, they will be saying to the council, we are assuming an obligation to you as to the accuracy of this information, and not just an obligation to their client. So that's a point we've raised a few times. We would like to see that in. And then I think the other point of substance is just what is the issues in dispute. And I don't know whether you, on cycle hire, etc., whether you want to hear why we say those things are necessary.
Yes, please.
Yeah. Do you want to, Vicky? Do you want to put that cycle hire?
Good morning. I'm Vicky Lewis. I was one of the case officers on the application. So the policy basis for asking for the cycle hire docking station in the Southwark plan is policy P53, which talks about development must contribute towards the provision of cycle hire schemes and docking stations. Financial contributions will be required from major developments commensurate to the scale and size of the proposal. And that request also came through from colleagues in TfL who are here this morning, if you need any more information about that. We recognise that there aren't any docking stations very close to the site at the moment. So our suggestion in the legal agreement was if a docking station were to be provided within 2 years of occupation of the development, then the obligation would be triggered to make a payment towards a new docking station.
And the level of payment for that would be?
It was 227,000, I believe.
Yes, that's right. So 227,000.
227, yeah.
Whilst we're on this point, does TfL want to raise anything? I don't know if they're here. You'd need to come onto the microphone system.
Yes, my name is Anne Crane. I'm the area manager in spatial planning at TfL. Yes, we did request, we requested a contribution towards cycle hire docking station. This is a standard request of ours. It's fully in line with London Plan policy. I can identify those policies if you wish me to do so, but obviously it's reflected also in the Southwark local plan.
Yes, could you just reaffirm the policy provision in the London plan, please?
It's T3?
T3.
Sorry. And we've secured contributions from many developers within Southwark towards cycle hire docking stations. A similar one, I'd say, to this development, albeit bigger, is that being undertaken by British Land and Canada Water, where we secured £1 million for 6 cycle hire docking stations. So seeking just one for residential scheme plus a supermarket with less car parking. Residential is car free, and various other commercial uses would seem appropriate to us and justified.
Understood, thank you. I'd like to invite the Rule 6 to
Thank you.
comments.
So just the only thing that we wanted to address was the review mechanism, but of course the sections that we've just looked at have dealt with some of that. And then there's the later stage review as well in the other sections that we haven't got to. Did you want us to address you on the review mechanism now, or did you want to wait until the end of the small details are addressed?
I'd like to hear it now, please.
Okay, so I'm going to invite Ms. Seymour to contribute to this, but I'll just give you the main 4 areas that we are concerned about in relation to the review mechanism. The first is in relation to the fixing of the finance rate, and this is the difference between the council and the appellants on this issue is to the tune of about £5 million. And just to give that in equivalent terms, you're looking at about roughly 13 affordable homes. The second issue is in relation to the profit target. Again, the dispute seems to be the 20% versus the 17.5%. And again, based on Annex C of Ms. Seymour's evidence, the 17.5% we say is the appropriate way forward. And that's what happened in the Stag Brewery and the Cuba Street cases that the appellants have been extolling the virtues. And again, giving you the difference between those two figures of 20% versus 17.5%, that's 40 homes equivalent. And then the next is about the surplus share at the end and what that looks like. And I think the council's position on this, I'm going to just invite Ms. Seymour to just explain what that is about, because I think I'm not quite fully up to date on that. And then the mid-stage review is something else that I'm going to ask Ms. Seymour to comment on.
Just before that happens, sir, I'm a bit concerned because we had Mr. Venning give his evidence. We've got the Rule 6 statement from the Rule 6 party saying they weren't challenging any of the figures that fed into the FVAs. I went through with Mr. Venning really carefully the component parts of that, which included the profit rate, which has been agreed by the local funds given for it. And he agreed that that was appropriate. And I'm very nervous that what seems to be happening is that that formal position of the Rule 6.6 in relation to those matters now seems to be reversed out of. Now, if that were going to be the case, I would have dealt with our viability witness on those issues. But given the assurances from my learned friend and from Mr. Venning that that wasn't going to happen, I didn't. So it's a fairness point.
Yeah, I mean, Mr. Harris does have a point.
I'm not sure I understand the point, in the sense that our evidence was clear that we were not challenging the evidence that was put forward by the council and by the appellants on viability evidence. We agreed in our evidence specifically with Mr. Venning that we were not disputing the fact that there were processes followed. What we're saying now is, in relation to trying to capture what this looks like through the review mechanism, we're not asking you to do something more radical or even radical in any way, shape or form than the Stag Brewery decision and the Cuba Street decision that my learned friend has been taking every opportunity to tell us about. And so if we're being suggested now that you following what your colleagues have done in other cases is totally inappropriate in this case, purely on the basis that we didn't put forward a viability evidence that supports that, I don't think that's a fairness point. So I'll make that clear. And what we're saying here is purely what's happened elsewhere. And because we haven't then tried to suggest that a different rate should be challenged in a more formal way, when we had nothing to do with the viability discussions in this case, it's just not right. But I'm in your hands about how you deal with that.
I think some of these points are going to have to be dealt with in closing, but this is a roundtable discussion about the legal agreement before me. So I am inviting comments on it. I have heard what Mr. Harris has just said about fairness issues. I do have those in mind. So as long as yeah, indeed. So as long as the Rule 6 is aware of this, and perhaps any cost implications that might arise. So you were going to pass, I think, to... Sorry, I didn't get your name.
Jane Seymour.
Jane Seymour.
Thank you, sir. I just wanted to make a couple of comments about some of the inputs that are in the UU at the moment.
Some of the what? Sorry.
Sorry. Some of the inputs, some of the assumptions that are stated in the UU and will be carried forward into the viability reviews. So just to explain that the viability reviews are structured, so it's a whole scheme review. So it effectively reruns the appraisal. So the first point of concern I have is around fixing the finance rate at 8%. That 8% is something that was assumed by Berkeley Homes when they submitted their original FVA back in July last year. But we've seen a 1.25% fall in the base rate since then. So effectively it would be fixing the finance costs. at a rate, currently at the very, very top end of what we expected. And my view would be that that should be a variable rate, that the finance rate should be set at each review. And that is a much more standard approach. I haven't seen a fixed finance rate in a Section 106 in the ones that I've looked at. So that would be the first point I would make.
You're saying it's normally a variable rate?
It's a cost that's taken into account in the reassessment of viability. There's not a stated fixed rate, because obviously this programme is potentially 10 years or more, and no one really knows how finance costs will increase or decrease over that period. So it's probably fairer to both parties that is a variable rate evidenced at each review. The second point I'd like to make is about the target return agreed on the market housing. I mean, I know 20% has been agreed between the council and the appellant, but that is extremely high. And 17.5% was the agreed target on the market housing at Cuba Street, which was a very, very tall tower, and Stag Brewery, where the inspector noted that that was a very risky scheme. Had a river wall, it had listed buildings, it had all sorts of other risk factors. So I'm struggling to understand why 20% would be appropriate here. And also in Annex C, I set out a very large number of other cases where 17.5% has been agreed in terms of the profit hurdle on the market housing. I mean, the obvious implications for setting that target at a higher level is that it's harder to reach. In Annex C, I demonstrate that actually that you get, if you look at growth at a particular rate, you would get £16 million additional money for affordable housing if it's set at 17.5, but you would get nothing if it's set at 20. So it's very material. And that was the 40 additional affordable homes we just referenced. The final point I'd like to talk about is the surplus share. So this is very clearly set out in policy. The Mayor's Affordable Housing and Viability SPG, paragraph 3.65. You can find this all in Annex C to Mr. Venning's evidence, says that the standard approach is for all of the surplus to go to the LPA on the early stage review, and 60% of the surplus to the LPA should go to the 60% of the surplus should go to the LPA on the late stage review. That's very, very clearly set out in policy, and all of the Section 106 agreements that I referenced in that annex, that is the arrangement. The mid-stage review, there isn't a clear policy position, but I would just point you in the direction of the Stag Brewery, Section 106, where there were 2 mid-stage reviews, and in both of those reviews, all of the surplus was provided to the council for additional affordable housing. There have been other examples of where there's been up to a 60% share to the council, but never less than that. Whereas I note here that it's been agreed a 50-50 split, but that seems to be without precedent and without policy basis as well. And obviously the implications of all of these things cumulatively is that the reviews will be less effective, they won't be comprehensive, and so they would not comply with paragraph 4.43 of the London Plan that requires comprehensive viability reviews in order for the maximum viable amount of affordable housing to be provided. Meaning some of the concerns that we have about the agreed inputs and how they will impact on additional affordable housing.
Okay, so those points aside, you would say it's still a standard agreement across London?
Yes.
But those are the specific points where it's not a standard agreement?
That'd be right, but they're very material.
Okay. I'm going to turn to the appellants team just to get their views.
So on the specific viability points, I'll pass over to Mr. Levine, and then after he's finished, I'll just come back to some of the other points that were raised, if that's okay.
Yeah, go ahead.
Good morning. Good morning, Jane. So I suppose the first thing to say is there were 3 issues raised there. I don't necessarily recognise the delta, the additional affordable housing that they're referring to. They're not figures I've seen before, and they don't necessarily correlate with what we've done previously looking at these issues. But I think that's a sort of side issue. I think on the main issues themselves, the fixing of the rate at 8%, Ms. Seymour's correct. BPS were consistently at 7%. We were at 8%. We set out in the financial viability assessment last year as to why we thought the rate 8% at the time was right. The BMPP evidence base underpins the policy November 17. That was at a 7% finance rate. So that's the cost of debt in the development. At the time, the Bank of England base rate was 0.25 and it changed in November 17 to 0.5. So there was roughly a 6.5% delta. Bank of England base rate at today's date is 4%. So we're at a 4% delta. And I believe there's also recent appeal decisions with finance rates that have been evidenced at higher rates. We could provide those if needed. I believe the 8% discussions with BPS, I believe Andrew Jones is on the call on the screen. I believe that is agreed with the council, further to discussions we had last week in the last few weeks. The second point was the target rate of return. Ms. Seymour's referring...
the variable rate point. What's your response to that?
We're looking to try and get some certainty here. We've agreed an all inputs review. Finance rates are very, very difficult. 10-year swap rates at the moment are about 4.5%, which would suggest that finance rates, or the Bank of England risk-free rate over the next 10 years, there invariably will be some movement, but we're looking to try and get some certainty into the process. So we've fixed a number of inputs: the benchmark land value, the developer return, and the target rate of finance.
Okay, sorry, continue.
No, thank you. The 20% figure, worth noting, it's 20% on the market residential, it's 15% on the commercial, 10% on the provision of the Morrisons, and 6% on the affordable. So that derives a blended rate, which was in accordance with the PBG. The 20% is agreed with Andrew Jones, with BPS, with the council. The justification that we set out in the financial assessment was agreed. Ms. Seymour refers to it being extremely high. Developer return is a function of risk, and that's where we are in the market right now, and that's deemed to be acceptable. So, and it probably reflects the government GLA's recent announcement on the challenges the market is facing. So the target rate of return is entirely consistent with the policy requirements, and it's certainly at a level from a valuation perspective I would also be looking at on a scheme of this nature, which is high risk. And then the point around surplus share, the GLA's position set out in the SPG, which Ms. Seymour helpfully referred to, 3.65. We have an agreed position with the council, which is 50-50. That reflects the council's own SPD, I believe, and I'll stand to be corrected, but I believe that's still the case. And I think Ms. Lewis and I discussed that a couple of weeks ago. That's 50-50. So once the appraisal has been rerun, any surplus over and above the agreed target rate of return would be split at the early stage, the mid stage, and the late stage review. And whilst it's consistent with the council's guidance on policy, one of the other reasons we were initially seeking 60-40 in the appellant's favour, and the reason for that was simply, again, down to risk. It was to reflect the over provision of affordable housing up front. So it was an opportunity to claw back some additional return before additional obligations were. So we've yielded on that. We're at 50-50, which is agreed with the council and the council's advisor. So hopefully that's helpful, but obviously happy to answer questions.
That assists, thank you. I think the appellant wanted to make some more points.
Yes, if I can just come back on three of the points that were raised in the council and from TfL. So the first one was Mr. Arnott said that it wouldn't be, I can't remember his exact words, but not right for there to be a dispute resolution process in a unilateral undertaking. That's not correct, sir. There's nothing that says, there's obviously nothing that means that this can't happen. And indeed, because a UU is one-way traffic, if you like, there's no contractual nexus between us and the council in that regard. So throughout the document, there are many obligations where we are seeking the council's approval for things. And of course, if it's unilateral, we have no contractual link to them. And therefore, we've drafted the dispute resolution clause to say, in the event the council refuses our submission or they don't provide a decision within 20 working days, we can refer the matter to an independent expert. And we've drafted in that the council may participate in that process, although they're not obliged to, of course, because they wouldn't be a party to the deed, but they have rights to feed in representations into that process. The independent expert would decide the matter, and then we would abide by his or her decision. So that's entirely reasonable in my regard. Of course, hopefully, if we're able to get a bilateral deed, then we can mutually agree a dispute resolution process. Second point was Mr. Turney referred to requirement, ideally the council having a duty of care from the appellant's viability consultant. I don't consider that's necessary. If you look, sir, at in part 3 viability, paragraph 3.2, the council may appoint an external consultant to advise them on the viability review submissions. And if you look at 3.5, the appellant is required to pay the council's costs on that advice. So they would have access to their own professional advice on all viability reviews, as indeed they have done from BPS in relation to the application stage viability material. Therefore, I don't see any need for there to be a duty of care from the appellant's advisor. Lastly, TfL, there was a request for the cycle hire docking station contribution to be paid if a scheme is proposed, I think within 2 years of occupation of the scheme. My instructions are that can be agreed. Obviously, we'd work out the detailed drafting with the council on that one. But yes, that would be okay. We would keep the contribution in a blue pencil schedule because we fundamentally don't agree it's required, but we will facilitate the request of the council on that. So in the event you find that it does meet the Reg 122 test, then it would take effect on that basis.
Understood. Thank you. Does the council have any other points to make?
Just conscious of time, but just very briefly on the dispute resolution point, I think I disagree with in the sense that the provision as I read it at the moment is so that if dispute resolution is triggered, then the determination is binding on the council in relation to that, and that is fundamentally that's not a you can't proceed on that basis if it's unilateral, obviously. So we can respond on that point in closing, but obviously if we reach a point where we end up with a bilateral, then in the usual way a dispute resolution clause would be drawn up and entered into on the basis of the council's template wording for that.
Okay, understood. I'm conscious of time. Does the Rule 6 want to mention anything else?
Not on this point specifically, but just on the point about the 7% versus the variable number. Do you remember that? I just thought it'd be worth. Mr. Levine had pointed out that the council, BPS and the GLA in particular, were pushing for 7% before. Do you remember that? I just thought I'd give you a reference to the officer's report for you to just get your headings on that. It's at 3.1, core document 3.1, page 172, page 102 internal. The council, I think, were at some point pushing for 7.5 in the negotiations, but they're not pursuing that. But our position being what you've heard from us in terms of the variable. So I don't think I need to say anything.
Okay, thank you. I'll go back to the appellants just to see if they have anything else to raise.
The only other point I was going to say on the variable rate, and I probably need to discuss with people on this other table, but I think we'd be happy with the variable rate, but on the basis it was at the same margin as the council's evidence base at the time, which was the 0.5 versus 7, the 6.5% margin. I suppose the problem we had when we had a discussion around variable rate was the problem that we had around the variable rate was we didn't agree with the margin. The bank would set the rate that they want to lend money at dependent on risk. And we didn't feel that the variable rate that was being proposed through the helpful discussions I had with Andrew Jones was broad enough. So the variable rate, probably something I need to discuss with people on the side of the table, as I say, but a variable rate could be a solution, but only assuming that there was parity, I suppose, with the evidence base.
Just to flag that, the reason that I smirk at that is that would be, if it was written in today, a 10.5% finance rate.
Yeah.
That's the point. And the key point, as Mr. Levine well knows, and we all know around in the room, is that the cost of finance, the evidence about the cost of finance does not necessarily track the Bank of England base rate. The two things move independently, hence him proposing an 8% finance rate in this review mechanism today, even though that's only 4% above the Bank of England base rate. So the cost of finance, we've had the dispute, we've been through it with him. BPS's position, the GLA's position was 7%. We've decided it's a point, given that we were at 7.5 in negotiations, a point that from our side is not worth troubling you with. But I'd certainly resist the idea that we get another draft of this, which is variable base rate at Bank of England plus 6.5, because that's inconsistent with all of the experts' views.
So I think we're saying 8.
Yeah.
The local authority is saying 8. Variable was mentioned. We were just trying to be helpful and saying, here's the issue with variable. Our position is 8.
Yeah.
Your position is 8.
Our position is 7, but we've said we're not going to.
Your position is 8.
Well, so if you go to the officer's report, Mr. Mohammed took you there. We have been absolutely clear that the BPS outturn of the viability appraisal process gets to a different figure than the appellant's figure, because we disagree with some of the assumptions. However, for the purposes of the FBA testing under London Plan policy
And the Section 106?
it doesn't matter. In the Section 106, we've decided it's a point not worth taking.
Thank
but
you.
the 7% rate is not the position that BPS took in the viability appraisal, as Mr. Harris well knows, and I don't think it's appropriate to take that sort of opportunism here.
Forgive me. The inspector's wanting to know what the various parties' positions are. We're saying 8. You're not saying other than 8.
Okay, that for the purpose of the 106, that's correct. For the purposes of the viability information that is before the inquiry, where the outturn of it is not disputed, we are saying 7. Just to be absolutely
it is just the section 106 we're discussing. Okay, understood. Are there any remaining parts of the agreement the appellant's team would like to go through? It's split into phase 1.
Yeah, so we can move on to phase 2 if you're happy, sir.
Yeah, I am. I'm conscious there might be a fire alarm at 11 o'clock.
11 o'clock.
11 o'clock. So I'm happy to hear you, but there's going to be a fire alarm shortly.
Okay, thanks, sir. So, as we say, moving on to the second part of the document, which deals with phase 2 then, and that starts on page 70 of the draft. Starts off with financial contributions. These are broadly similar to those. They're just split, so they're broadly similar to those we mentioned in phase 1. Then in part 2, we've got affordable housing, and this is the delivery of the intermediate element of the affordable housing. We discussed in it was discussed in evidence about the CLT requirement, and you'll see, sir, at paragraph 1 of part 2, that's the reasonable endeavours covenant on the appellant to work with a community land trust to try and facilitate the delivery of CLT homes in phase 2. And you'll see there, I won't read them out, but you'll see the list of activities the appellant is committing to undertake to try and achieve that endeavours covenant in 111 to 114. If CLT, if the homes can't be delivered as CLT homes, then they will be delivered as intermediate homes. So they will be delivered. It's just the tenure. Then the rest of it is fairly standard planning obligations for delivery of affordable, much like in phase 1. There are a couple of council. There's the phase 2 affordable housing mix schedule. There's a part appendix A, and then the council's housing and delivery monitoring table is the appendix B. We then have at part 3 the late stage viability review, which will be triggered on 75% occupations. That is all the same. The process wise is all the same as we've discussed in phase 1. We've then got delivery of wheelchair housing, and we discussed that. Same as phase 1 in part 4. next bit is part 5, which is probably worth spending a bit of time on, which is the provisions relating to small shops and local independent business operators. So, sir, I think it's been raised in evidence, particularly by Mr. Alston yesterday. You will have seen what we're calling the LIO, or Local Independent Operator Schedule, which is the table with the ticks and crosses showing what each of the different types of operator, the planning obligation benefits they get under this agreement. So in broad terms, you heard about this yesterday, so I'll try not to repeat too much, but there are 2 existing small shop operators on the site, Just For You and Factory Outlet. So, and then there are the other, what we call existing retail and bricks and mortar tenants who, by virtue of the size of the premises they occupy, don't qualify as a small shop, but they do qualify either as a local or independent trader, and therefore they get some benefits. There are then the handcart operators, and finally the operators in the marketplace food court, who are referred to as the marketplace operators. All of the different businesses that qualify for the different types in Part A are listed in Part B, along with for the bricks and mortar people, in column 2, the area of the floor space that they occupy. So all of them get access to the activities the appellant will undertake under the final relocation and small shop strategy, which is in paragraph 1. That has been drafted in line with the council policy. I think it's P23. There are some bespoke provisions here, principally in relation to 127. So that is a requirement in the, we'll come on to it, but for those that get a right to return, there will obviously need to be a negotiation process of a lease that they take in the new development, and the timescales and processes for all of that will be set out in the strategy. There's been some references to temporary relocation on site, and whilst the appellant position currently is that wouldn't be achievable on a construction site, there is reference there to us continuing to keep that under review and do so where it's logistically achievable at 128. We've added in, at request of the council, it was added in at 129, a requirement on us to explore the market for a food court operator to come back into the scheme. Clearly, we're talking about a number of years in the future, and a market we can't predict at the moment. So that's why that can obviously only be a reasonable endeavours obligation. And indeed, were we able to find a food court operator to come into the scheme on a feasible and viable basis, we would then have to try and get into that lease or agreement for lease, a requirement for them to facilitate requests from the market place operators were they to wish to come back. So that's why that's dealt with at 129. And then finally at 1210, there's a requirement on us to refresh the EQIA at the point of the submission of the final relocation and small shop strategy. We've then got at paragraph 2, the independent business advisor that will be funded by the appellant, and will work with the council in amongst other matters, administering the relocation fund. At paragraph 3, we've got relocation opportunities. So that's prior to the closure of the centre for the appellant to share information with the local independent operators as to the vacant units within the Rye Lane and Peckham Ward areas. And Mr. Alston talked about the sort of vacancies that exist in his evidence yesterday.
Could I just check with you before you move on?
Yes.
The clauses that you've just taken me through, 1, 2, 3.
Yeah.
Are those in addition to what the council has in terms of business support? There's a clear separation. So this is
Yes.
the appellant providing these things. So in terms of what the council has in terms of business support, has that been taken into account in planning these approaches, or is this just completely from the appellant's perspective?
This is from the appellant's perspective, and it's specifically to respond to the requirements of P33 and the business relocation strategy. So it's over and above anything that the council may provide generally.
Okay.
So then, Sarah, paragraph 4, we've got the appellant's payment of the relocation fund to the council. And you can see at 4.3 there the types of matters that fund can be used to assist with. So access to professional services for the local independent operators, relocation costs, and other services deemed appropriate. And I'd say that will be administered by the council in conjunction with the independent business advisor. There's some controls there on paragraph 5 on essentially to give 6 months notice prior to the closure of the shopping centre. We then move on to the requirement in paragraph 6 to provide the small shop space. And in that, at paragraph 7, that's the ability for the existing small shop tenants, so Just For You and Factory Outlet, to, if they wish to do so, relocate back into the scheme in one of those small shop units. And obviously the processes, negotiation timelines, etc., for all of that will be in the strategy that we referred to. They get the benefit of the preferential terms that you can see in paragraph 8 in terms of lease, most notably first year rent free, and then in years 2 to 5 a rent of 80% of the local market rent. The local market rent is set in accordance with standard Southwark drafting at 8.2. The other bricks and mortar tenants who don't qualify as small shops but are local/independent operators, they will get the right to return on those preferential terms if the council elects for some or all of the affordable workspace, which we'll come on to be delivered as affordable retail. If that's not available, then those people are able to come back on market terms. We then have the hand cart operators at paragraph 9. So this is the requirement on the appellant to explore opportunities to create an outdoor space for the hand carts to relocate to. And then at paragraph 10, we have an additional provision which we included at request of the council to allow the marketplace operators, so those are the food court operators, to potentially return to the development into a brick and mortar premises. So you will see that there at paragraph 10, the appellant is committing at the same date, the council's required to notify it as to whether it wants affordable workspace or affordable retail. So that's 18 months prior to submitting our Gateway 2 application for phase 2. We will use our reasonable endeavours to contact the marketplace operators and provide them with a floor plan of the retail units in phase 2, and mark on that plan where it would be possible for a unit to be subdivided, so obviously potentially smaller space to be created, and those people, if they wish to, can elect to come back on market terms, and then the process for that negotiation will be in the strategy as well. Part 6 is affordable workspace and affordable retail. This is the obligation on the appellant to deliver affordable workspace as the sort of default position, But as we mentioned, the council has the ability, in discussions, there's been requests from the council to provide more affordable retail. And so we've provided the option for the council to elect for some or all of that affordable workspace to be delivered as affordable retail. The process is set out in the part 6 there. So you could have a scenario where it's either a all affordable retail, all affordable workspace, or a mix. And then the provisions for delivery flow through depending on the council's decision. If the council don't give a response to that, it'll be delivered as affordable workspace in default. If it's delivered as affordable retail, you will see there in part C at 7.5 the preferential terms there for that affordable retail. If it's delivered as affordable workspace, the heads of terms and the specification for that are attached in Appendix 1 and Appendix 2. The affordable workspace is made available for 30 years in accordance with council policy at 20% discount on local market rent. Part 7, we've got delivery of public realm. Again, that replicates what we had in part 1. For phase 1. Part A deals with similar matters to phase 1 in terms of car club, parking permit restrictions, and bus station improvement works. So in terms of the bus station, that will be the physical delivery of the bus station improvement scheme works. Part 9 is standard Southwark drafting, again, to achieve local employment opportunities and local supply chain benefits, and also end use employment. Part 10 is estate management plan. Part 11, again, habitat management and monitoring plan to achieve the legal requirements of biodiversity net gain. Part 12 is the same standard London-wide provisions for energy sustainability, district heat network and monitoring. We then have at Schedule 3 the list of registered providers that can take the affordable housing. Schedule 4 is the now what we're hoping will be the redundant reference to the blue pencil schedule, and I would suggest that would be what would become the cycle hire docking schedule for you to decide whether or not it's applicable or not. Obviously, that's on the assumption that the council, the position is as we hope it is. Appendix 2 is the bus station improvement works framework. So that's the framework of works for the bus station. That's your frame of reference, essentially, for the works that will be in the bus station improvement scheme. And I think that is it. Obviously, there's a list of plans. I think you have those. If not, we can send them. There's obviously various plan references in the document. So,
yeah, I mean, the plans I've got are the ones that are the core documents. So unless there's any variance with those, I'd need to know. Does the council have any views on what they've heard?
Thanks, sir. I think we can go to part 5 of this schedule, this schedule 2, which is about the relocation and small shop strategy. But can I just ask you to, having gone there, just to flip back to page 22 of the document as well, just to understand local independent operators, because this is an important definition in the agreement or in the undertaking. So the definition of local independent operators is confined to the businesses which are listed as the existing local independent operators. So it wouldn't include any person who later occupies, for example, a handcart between now and the development coming forward. It only includes, it fixes the potential beneficiaries of these provisions as at the date of the deed.
Could I ask what would be the length of the lease for a handcart operator if that was the case?
I don't know.
Would it be 6 months?
I don't know. Barclay are their tenant, are their landlords. I'm sure we know.
Yeah, I mean, I'll pass over to the client team. I mean, just to say, I'm not sure where this point's going, but the reason for fixing the local independent operators now is, of course, anybody who comes into the scheme after this agreement will take effect were you to grant planning permission. Anybody who comes along later will have full knowledge that the site's going to be redeveloped, and therefore come in with that knowledge. I'll pass to the client team about the tenure terms of the handcart operators.
But they're monthly licenses. Yeah.
So that's the first point, that it's confined. I just want to, the reason I want to just flag that is that you've got to understand the provisions on the basis that the largest cohort of people that could possibly benefit are these listed operators. So when it takes effect, that list may be shorter because some of those people may no longer be there. And the reason you need to look at the definition of local independent operators is because that is only the people on the list, and only insofar as they are still there and not in arrears as at the date that the final relocation strategy is approved. So I just want to flag that in terms of the scope of these provisions at the outset, so that everyone understands that. There's a point of detail that perhaps can be clarified, but the local independent operators definition in point B refers to lawfully hold a lease or license with the developer, including any subletting or assignments which have been made with the approval of the developer. And given what you heard from Mr. Alston yesterday, I just wanted to clarify with the appellant, does that include the MPOs, does it, the marketplace operators? That they do hold a lease or license with the developer, or their license is approved by the developer?
We don't need this for marketplace.
So there's potentially, it may be something that the appellant can just, it's maybe they're in error, but B would seem to exclude a marketplace operator at stage one.
That isn't the intention. We can tighten that way.
Okay, thank you. So that might just be a small drafting point that can be taken away. So that's the sort of context as to who's within the local independent operators. And then when we get to part 5, the provision of a final relocation and small shop strategy, in principle, that's a matter which has been agreed. You've seen it in the committee report that some of the detail is going to have to wait because the length of time involved, and that a final strategy is required. And the council anticipates that that will be an important document for it to review and comment on. We'll do that obviously in due course. I just want to then pick up the nature of the obligations. And first of all, I just wanted to flag paragraph 1.2.9 in this part 5. It's page 81. Mr. Lockerbie described it as reasonable endeavours to find a market hall operator. That's not how I read the provision. It's explore the market for a food hall operator to take a lease, and in the event there is market interest, to use reasonable endeavours to create such a lease. So that's obviously a sort of a caveat on when the reasonable endeavours engage, because it's not reasonable endeavours to find an operator. It's think about whether there's a market for it, and then if it's concluded that that is feasible and viable by the developer, to then use reasonable endeavours to take that forward. So I just flagged that in terms of the effectiveness of the provisions as drafted. Next point, there's mention of the relocation fund. I just wanted to flag that that relocation fund is a sum that's defined, has been established by the council. Mr. Pearce from the council business side of the council can help with the £200,000 fund and why that's been quantified in that way, but we're content with that provision. Then can we go to paragraph 7, page 83? And I just want to, because there's a risk that the sort of the summary table doesn't quite capture the difference of the provisions. So existing small shop tenants, that's just for you and factory outlets, as Mr. Lockerbie says. Those two tenants, assuming they're still there at the date of implementation of the scheme, they could then have what's called a right to return to the development, and you see that in paragraph 7.1 for a small shop unit. And then there's provision 7.2 in that respect. For the other local independent operators who have a business premises, which is Deuces, Wing Tie, Pack, and Image, those four businesses, it's not a right to return. It's a right to request that they return to the development to take a commercial unit that is available. So it's not framed in the same way, and one assumes that the difference of language is deliberate, because otherwise they would have just used the same phrase, shall have a right to return to the development. So those four local independent operators can just make a request, and of course whether or not the owner of the shopping provision, the retail provision, accedes to that request is a matter which is not controlled by the agreement, or by the undertaking as it now is. So that's paragraph 7.3 for the existing retail bricks and mortar tenants. The small shops units heads of terms, and the same point arises in respect of the heads of terms for affordable retail. Just to flag that the policy in P33 paragraph 3 requires consideration of the specific servicing, fit out and lease terms. So that's what would be expected to be in a final business relocation strategy. But in fact, those terms are being fixed now in this structure. So in other words, it's the discount 1 year rent free and then 80% local market rent are being fixed now. And I think, as we heard yesterday, those terms have not been tested against the actual requirements of the occupiers.
Does the council oppose that?
Sorry?
Is the council opposing that element?
Yeah, in terms of understanding where that 80% rent has come from, it may be that it can be justified, but at the moment it's not clear how that is to fit into the requirements of policy to take into account the specific business requirements. Paragraph 9. This is the handcart operator space, and we heard about this yesterday as well. So you know the point, sir, that this is not part of the planning application, and I think Mr. Alston's view was it would require a further planning application to be made for such space to be delivered within the scheme. And again, I just want to emphasise that this is not a reasonable endeavours to incorporate the handcart operators, but rather reasonable endeavours to explore the possibility of providing the opportunity to return. So it's the sort of additional caveats of explore the possibility. So it's not reasonable endeavours to get them back in or a commitment to get them back in. It's reasonable endeavours to explore the possibility of providing. And so obviously that means that those people are treated differently from the other small shops. And you had the point yesterday, sir, that under P32, the parties are in agreement that P32 and the obligations in P32 apply to both the handcart operators and to the two existing small shop tenants. There's no difference in policy terms between those two cohorts. And then the third cohort, or the fourth cohort, if you include the existing BMTs, is the marketplace operators. So the way in which they're being dealt with is different again. And you know here there's a point of difference, sir, that we say they are small shops within the policy definition. The appellant says they're not. if we're right and they are small shops, then there's no justification for treating them differently from the small shops. And again, just taking the obligation at its face and to flag it, that this is a reasonable endeavours to contact the marketplace operators, provide them with a floor plan, and then tell them what's available. So in other words, this is sort of, you must market directly to the marketplace operators rather than an obligation to offer them any particular terms. And then the final point, just that we wanted to flag, and there's throughout this schedule there are quite a few cross-referencing problems that obviously the appellant will want to pick up, and I can certainly hand over my marked up version. Sorry, I'm just going to go on to. Oh, sorry, can I just deal with that first, and then we'll come back on. Mr. Arnott will come in on drafting, but just the final point I want to pick up on that schedule is if you go to Part C, page 88. You see under the heading affordable retail delivery at the bottom of the page, and then over the page the terms of the affordable retail delivery. Now, envisage the situation where there is none of the existing local independent operators are, well, there may be no existing local independent operators, or none of them wish to take affordable retail space in the future. So this could be 10 years down the line. In those circumstances, there's no provision here for a cascade for that, who should be able to take that space. So all it is that they need to make the space available on those terms. So if you see the terms at 7.5 on the affordable retail, now those terms could be offered to Costa Coffee or Tesco, and that would discharge the obligation because they're not required to be offered to the types of small businesses that council policy seeks to protect. And the normal provision is the one that you see under the definition in local independent operators, which is 50 employees or less and do not trade from more than 3 locations. So there's no provision that it goes to those people in the event that the defined local independent operators are out of the picture. I think Mr. Arnott had another drafting point.
Yeah, I'll just keep it very brief. There's just 3 points on the drafting as it stands for Part 5. And the first one, I suppose, is maybe slightly more than a drafting point, but it's the provision for the final relocation strategy at the moment. There's no requirement on its face for the appellant to consult with the local independent operators, and that's explicit requirement of policy P33. That they consult, and I think the council's expectation would be that they would consult, and that part of the strategy, parameters of the strategy, would be requiring evidence of consultation, and that to be demonstrated to the council's.
Is there a defined period that you're referring to?
So the policy itself talks about the submission of a business relocation strategy being undertaken in consultation, but it doesn't then descend into the detail about how long. But what I'd say at the moment is there's no, on the face of the schedule at the moment, there's no requirement to consult the local independent operators. So they may, but there's no requirement on the face of the undertaking at the moment. The second point is, given the importance of this strategy, we would hope and anticipate and expect that there would be a requirement then for subsequent monitoring. So specific monitoring reports at intervals to be agreed to provide the council with details of evidence of the appellant's compliance with what will be a huge raft of commitments and obligations within the strategy. So that would be something, again, that if we're looking to explore a bilateral, the council would be expecting specific monitoring report requirements for a strategy of this magnitude, because at the moment it's submitted, and if it was to be approved, there's no, other than general monitoring, the council would expect in this scenario specific monitoring reports to be provided. And the final point was on drafting was, I think, para 1.6 at the moment in Part 5, and that seems to suggest that if the council don't approve the strategy within 6 months, that all of the obligations in Part 5, so that's all of the relocation small shop strategy obligations, would fall away. And I don't know whether that's a drafting point, because, well, what if the council was to refuse the strategy? That only seems to assume they have 6 months to approve it. And the reason for the 6 months is that the council, when it went to members in July, they obviously understand the critical importance of this strategy, And part of the resolution was that it would be this, perhaps slightly unusually, but this strategy would be one was to be considered and approved by members at committee. So hence the 6-month period. But the council couldn't accept, and obviously on the appellant's own case, these obligations are necessary to make the development acceptable in planning terms. And yet this para 1.6 seems to be suggesting if it's not approved, then they fall away. So all of the entirety of the obligations would fall away in that scenario.
So sorry, can I just one more thing, because I've just been reminded, just to clarify, in terms of the lease terms, there's no issue from the council side with the affordable retail lease terms being rent free for 0 to 12 months and 80% of local market rent for years 2 to 5.
In the table.
In the table,
Okay.
yeah. I just want to make that absolutely clear.
Okay, and all understood. I'm going to turn to the Rule 6 party, Mr. Mohammed.
Thank you. So 2 brief observations before I ask Mr. Holloway to respond to the specific parts. You will have heard what Mr. Turney had to say in relation to the wordings contained at section 7.1 and then through to the particular provisions around the handcart. I don't say anything about those points which we were going to raise, but I just make the simple observation that from the community's perspective, the wording, the purpose that sits behind it, and the way that it's been drafted is deliberate. And it's deliberate for 2 reasons. One is to make it as difficult as possible for these businesses to ever return or succeed in returning. And I think that has got to be part of the equation, because when you then read the way that those provisions are worded, they're not legal drafting points that are specifically designed to make this agreement work. What they're specifically designed to do is to make this as difficult as possible for this community. But crucially, when you sit and read those words again, and you then understand what P32 and what P33 is trying to achieve, you will no doubt be left with a clear understanding that not only does it not meet policy, but that's the intention behind it. And then the final thing is to observe again that yesterday, Mr. Alston's evidence was very clear in relation to the 2 businesses that are finally now included in the bricks and mortars that we were discussing yesterday. You will recall him just being very dismissive about the fact that this is now completely irrelevant because they're now included in the section 106 anyway. But in January of this year, in Mr. Holloway's evidence, we were telling them they should be included. None of that was picked up in his proof. In his rebuttal, it was still a maybe. And now we're being dismissively told we're included anyway, so what's the problem? And that's the context in which we find ourselves now, of 2 really important businesses that were always excluded. Now they're included, and the wording makes it really clear that we're going to try and make it as difficult as possible for you. And so that's the kind of overarching point. But on the specific points about the handcarts and others, I'm going to ask Mr. Holloway to say something.
Thank you. I won't repeat what the council said. Largely we support it. So we really support their views on the handcart operators and the marketplace traders being small shops and therefore entitled to protection over P32. And just to emphasise, that includes retention. We agree with all the comments around sort of weakness of the language, it not only being reasonable endeavours, but reasonable endeavours to explore the opportunity to provide. I can't really think of weaker language than that you could put into a contract. And I would also just emphasise under P33(1), the consultation point that the council raised and the importance of that. Our view is that should already be present, that should have already happened, and there should be a policy compliant business relocation strategy submitted at this point to give you an idea of what this is going to look like, obviously with a view to it changing in future. The second part of that is remembering that P33 also requires the business relocation strategy to set out viable relocation options. So I think that word viable needs to be borne in mind as we go through all of this. I would also bear in mind P33(3), the requirement for any business returning to the site that should require specific business requirements, including fit out. There's currently no support at all for fit out when returning back to the site. And just to note, the relocation fund wouldn't cover the costs of fit out on the return.
Could I ask a question on that? Are there other aspects of the council that could provide such support?
Could the council provide?
Is there any general provision for, say, I don't know, high streets?
I'm not the person to ask, I'm afraid. But what I would say is
not that we're aware of, and so our view would be that you should assume that whatever support they're likely to get, if there's a gap, you should assume that that gap will not be filled by the council, as far as I'm concerned.
So my instructions are that there isn't another fund at the moment. I mean, obviously sometimes funds get created by other means, but at the moment there isn't.
Okay.
Yeah. Nor would I think it would be appropriate for the appellant to kind of rely on the council to kind of make up the harm that it's creating. So that's a kind of overview. We need to see that as the overarching requirements for all of these people. Again, no temporary relocation. So the return to the site for all of them needs to be borne in mind that is a requirement under P33. If you're going to return these businesses back to the site, there needs to be temporary relocation. Whether or not that's feasible is one thing, but that's going to seriously undermine whether or not these businesses are going to make it. And just on this point about how local independent operators are defined, and how it's not going to cover people in future, and it kind of bites at the 5-year point or whenever we get to this point. There is nothing to stop the appellant taking a somewhat hostile approach to ensure that none of the businesses are there when the time comes. So just to give some specific points about the paragraphs now. Paragraph 3 is titled Relocation Opportunities, but I just want to be clear on what it's actually achieving. It's just a database of available opportunities on the high street. It's not securing relocation opportunities. It's just basically going on, I don't know, the internet and Googling vacancies in Peckham. And there's nothing to say that those opportunities will be viable. It's just a very basic database of here's some vacancies. Paragraph 4, relocation fund. This is going to apply to all the businesses because there's no temporary relocation. So we need to bear in mind that's £200,000 across 24 businesses. That equates to £8,333 per business. As you heard from testimony from Latin Elephant on the first day, some businesses displaced from the shopping centre needed 100 times more than that. So that £200,000 needs to be seen in light of that. Some businesses needed high six figures, up to £1 million for their relocation, including fit out. So if we're looking at £8,000 per business in light of that, is that viable relocation? In an ideal world, the businesses would have already been consulted and it would have been tested on a present day basis as to whether what is being offered secures viable relocation. I hear the points that they're not going to move for 5 years, but I think the best thing we could have done at this point was test on a present day basis to see if it were to be now, would this secure viable relocation? My belief from what you've heard from Latin Elephant is that it wouldn't. But to be realistic and what could be achieved now in this agreement, given that failure has already happened, I think there should be a mechanism to ensure that this business relocation strategy includes consultation with traders and some sort of testing exercise with a clear conclusion as to whether this is actually going to achieve viable relocation. And if it's not, a potential to increase the fund to potentially capped, but to a much, much larger sum than what we're seeing here. On the heads of terms, there is no testing, again, as to whether the rent reductions will be viable for them. So I'm not just saying whether what the correct rent reduction would be, but if the goal is viable relocation, we simply do not know whether that's going to be sufficient. Again, there's no consultation. And again, I would note that the specification at the end of paragraph 8 makes clear that the appellant will not be covering fit-out costs. I would remind you of the wording in P33 that specifically says specific business requirements should be met, including fit-out. And I would remind you again of the CF commercial report that Mr. Turney flagged yesterday, which gave a suggestion that that's a particular hurdle for these businesses and should be covered by the appellant. On the final point I wanted to make is on the affordable retail and this hypothetically being provided. That is a function of special circumstances under P35, whereby the affordable workspace pivots to affordable retail. So if you get that, you lose the affordable workspace. So that benefit needs to be seen in light of that. It's satisfying paragraph P35. I don't think that should be sort of double counted and seen as also a benefit to satisfying P33, because when you do that, you're losing something else in the process. So I would consider it something of a sort of double dipping to say, well, look what we're providing for these businesses if we provide affordable retail, because it's coming at the loss of P30 affordable workspace. I don't want to repeat the other points that the council already made, so that's all I'm going to say. Thank you.
Thank you, all understood. I'm going to turn back to the appellants to see if they've got any views.
Yeah, thank you, sir. There's a lot to cover, so I'll try and remember every point that's been raised. But I mean, just as a starter, we do totally refute the Rule 6 position that this isn't policy compliant. We absolutely do consider this as a policy compliant offer, and we will set out the basis for that in submissions. But trying to remember each point in turn. So Mr. Turney raised the point about the food court operator and the reasonable endeavours in the strategy. We are more than happy to propose some firmer wording in terms of we will go out to the market. We will go out to the market and see if there's a food court operator available to take the space. But of course, you'll appreciate that will be a commercial arrangement. So obviously, the appellant needs to do that. Were there to be a tenant that's interested in taking the space, there would be a normal arm's length commercial negotiation on that. And of course, that process needs to be qualified by reasonable endeavours, because otherwise, the appellant would have to take a tenant on any terms, and that's very standard in these sorts of agreement. But we can work on the wording in terms of actually going out to the market on those things. Yeah, we're more than happy to add in to the final relocation small shops strategy a specific obligation to consult with the local independent operators. That's fine. Similarly, monitoring. There was a request for monitoring of our compliance, and with that strategy, again, happy to add a monitoring obligation in. Some points. I'm not sure whether I think at the end, Mr. Turney was saying the council were okay with the affordable retail terms, but
in the table, yes.
Yeah. And obviously the Rule 6 has made the point about the 20% being insufficient. We'd just like to re-emphasise there is no policy on affordable retail. There is on affordable workspace, but not on affordable retail. We've obviously made this offer to comply with the council's policies on trying to achieve feasible, where feasible, return to the development. I'd refer you to P32, where it says there should be full consideration to the feasibility of providing affordable and suitable space for existing occupiers in the completed development. While I'm on that, there's been a point by Mr. Holloway about fit out. Again, there's no specific. So our view on that is that because there's no policy to mandate affordable retail rent. Nonetheless, we are offering a 1 year rent free and then 20% discount in years 2 to 5. So the savings that engenders will allow, for example, that tenant to use those savings towards fit out costs. There was a point raised by the council about how, if they were to elect to have affordable retail, how that space might be used. First of all, I outlined how in the event they do elect to take the space as affordable retail, there is a requirement then for to serve the existing BMT tenants who aren't small shops into that space. That is in 7.3 of Part 5. But we again are happy to propose or try and work with the council to achieve some drafting to allow for there to be some parameters within which that affordable retail space can be used. Totally get the point that it's not for a large scale commercial operator to take that kind of space. Mr. Arnott raised the point about our obligation that the strategy that I think it's 1.6 that the schedule wouldn't have effect if we don't get the approval within 6 months. Our answer to that would be, I mean, as a matter of point, it should be perfectly capable for it to be approved within 6 months. In the event it's not, the dispute resolution process that I referred you to towards the beginning of the session specifically allows for the council to refer any matters to the dispute process if it goes beyond 20 working days. So the agreement does facilitate them to do that, and that's.
But that's also contested by the council, isn't it?
It is, but the appellant is. I mean, I don't agree on that, their position on that point. But our document, we are saying to them, you may refer this, you may refer something to dispute. It would be completely nonsensical for us to turn around at a dispute resolution stage and try and say that can't happen when we've written it in black and white in the document that it can.
Could revised wording not be considered, though, on the first point?
Sorry, so
the first point, I was taken to.
Oh, about the schedule falling away.
Yes.
Yeah. Yes, we can look at that. Yeah. Yeah. Absolutely. The business. There was a point from the Rule 6 about the quantum of the business relocation fund. Just to say that we specifically took advice from the council's officers on that. I think Mr. Pearce, who's here today. So yeah, we've done as we've been asked on that one. Sorry, and I think final point was Mr. Holloway made some criticisms about the strength of paragraph 9 and the handcart operator space. We are happy to propose some alternative drafting. We'll work out the detail with the council, but whereby we will make available space, open space at what's known as Peckham Yards, for the handcarts to come back. The Berkeley team, if you're interested, can probably just explain a bit more about that.
Yes, please.
The space sits to the northwest of the site. It's just behind where the clock tower is. You will have, it's what's currently the Morrison service yard. You will have seen it on your site walk around. That will become part of the main retail loop. So the traders, the handcart traders there would be on the main retail loop, key footfall route from Rye Lane through to Morrison's and the bus station. So that's the space that we would propose for the handcarts to go, so that they can benefit from those two key points.
So, and sir, sorry, just to in order that I don't forget, and just to sorry to tack back to something that I've been asked to raise with you. It's just on the cycle hire docking station contribution. We just wanted to put it on the record that that contribution the council had agreed prior to us having to convert to the UU. The council had agreed to that coming out of the document, and we, if you need to see it, we have correspondence on that. So we, we feel like, so we have that from them, and we do feel like we are, conceding quite a lot by allowing it to be a blue pencil clause, notwithstanding the fact that in the bilateral negotiations they said it could come out. Thank you.
Sorry, so just a small query. Mr. Lockerbie was referring to what Mr. Holloway suggested and said we're happy to look at it, but was only keen on talking to the council about that. We would very much welcome that if you're responding to an issue that we've raised, that we're part of that conversation as well.
We're more than happy to share the amendments we make to the document with Mr. Holloway.
Okay, thank you. All understood. Would the council like to make any further points?
Well, so just to note on the cycle hire docking, I mean, the point is that we've explained the policy basis, TfL have explained the policy basis. In the course of the bilateral negotiation, we could go through and we could point to all the things that had previously been offered by the appellant and then were changed. I think the point about bilateral is nothing's agreed until everything's agreed, and there's a clear policy case for this, and I think it's important to note that you've heard no reason from the appellant as to why it's not required.
Point taken, but is there any specific reason why the council chose to change its mind?
I think it was as part of, there was an attempt to get more movement on some other topics. and it was part of a negotiation over that. So there were a whole series of issues that were live, including terms of affordable housing viability review, including the terms of the business relocation and affordable retail strategies. There's been a whole series of points where there's been to and fro, and I think there's a risk of taking a snapshot, because we could take a different snapshot and show that, for example, the appellant had this in mind when it put forward the planning application and its transport statement. So these provisions were in the appellant's mind, and then they withdrew them from their offer to the council. So there was a lot of give and take going on in the bilateral negotiation. I suspect on that issue, if we had got to a position and we were showing you a bilateral which didn't include cycle hire, you would still have TfL sitting in the room saying they're not satisfied on that point.
Okay, thank you. I'll give the appellants the right of reply.
Before they have the final word on that, Mr. Holloway just wanted to clarify something that Mr. Lockerbie said.
Am I okay to respond to a couple of points, sir?
Yes.
Thank you. We welcome the inclusion of consultation, but of course, just consulting with the businesses doesn't achieve anything per se. There needs to at least be the option pursuant to that consultation for fit out to be included or the relocation fund to increase for that consultation to be meaningful. Note in policy that there is no determined discount to be achieved. That's true. But what is set out in policy is a requirement for the relocation to be viable. And there is a requirement under P33.3 that the return to site should include specific business requirements, including fit out. I have a feeling if they speak to those businesses, they're going to say their specific businesses requirements include fit out. So to be policy compliant, surely you then need to provide fit out. And on the relocation fund, I note that they took advice from council. You, sir, need to reach your own opinion as to whether that fund achieves the policy compliance. And I would really encourage you to bear in mind what you heard from the people on the first day.
Could I ask, what you referenced the 200,000 figure and then you referenced 1 million? Do you have
yeah, if you remember
a source of the 1 million?
Yeah, if you remember, sir, it was Latin Elephant, Sarah Goldswag, on the first day. It's in her speech, which is included in the core documents. She gave two examples, albeit largest businesses from the shopping centre, who suggested to Latin Elephant that the costs of their fit out would have been, I think one of them said, a high six-figure number, and one of them quoted £1 million, and they were permanently displaced as a result of the relocation fund not being sufficient to cover their needs. And in that case, the relocation fund was a much, much larger figure per business.
Okay, thank you. I'm going to return back to the appellants team.
I'll just give you the cross-reference for that so that you have, it's CD 12.11, page 3 of that document.
Thank you. Yes, I'd like to invite the appellants to make their responses if they've got any.
No, I don't think so, really. On the point, I mean, we made the point about fit out and the rental discounts. On the cycle hire, it was, appreciate, we've got a different view on that. That's okay. Our position is at the moment we are unable to find any stated intention from TfL that the cycle hire scheme will move this south of the river down to the site. But we're happy to agree that if a deliverable scheme is coming forward, then in accordance with what we talked about at the start, that if that happens within 2 years of occupation, then we'll pay the contribution.
Okay, thank you. I think that concludes everything on the section 106, unless anybody else wants to raise anything.
Do you want to come forward? The representative, whose name I don't know, from do you want to take a seat? Just raising something about the bus station.
Sorry, I'm not certain that we've bottomed out agreement between the three parties about the bus station improvement wording.
Okay, you represent. Who do you represent? Sorry.
Sorry, I'm from TfL.
TfL. Okay.
Yeah. There's been a lot of toing and froing on the provisions within the unilateral. I'm trying to confirm whether or not that wording has been agreed. In addition, there's conversations about a potential bilateral agreement. In that event, I would ask that either we are a signatory to the agreement in respect only of the bus station provisions, or alternatively, we are given third-party enforcement rights. Because obviously the bus station is extremely important to us from the point of view of operations and safety of passengers and everyone else using that facility. Is it possible to for us to confirm what it is that's being agreed now?
So just if I can assist, what you won't know is that Ms. Crane commented on the unilateral and its drafting in an email last night, which I think the appellant has. I think the position is from the council side that I don't think we've got any concerns with the changes, save that if this remains as what's proposed at the moment is that TfL would have to be a party to the agreement, and if they're not a party to the agreement, then some of the drafting would necessarily fall away because its covenant's being given to TfL.
I'm going to have to go back to the appellants on this to get.
Yeah, that's fine, sir. So we've seen Ms. Crane's email, and we can confirm that we will agree to give TfL rights under the Third Parties Act 1999 to enforce the specific provisions relating to the bus station. So we will agree to TfL having approval of the bus station improvement scheme. We will give them direct via third party rights enforcement as regards the covenant to do the works. And we will accept their proposals for a restriction on phase 2 until those works are done, but on the proviso that TfL have given the appellant all the rights they need to do the works, because of course you'll appreciate we can't do them unless we have their property rights to do so.
And that would be under the premise that TfL are a signatory of the agreement?
No, sir. If you look at the front end, in clause 17, there's a reference to the Contracts Rights of Third Parties Act 1999. Now, it's not what you see there is currently the normal position whereby this is a particular it's a statute that allows for parties who are not a signatory to a contract to nonetheless enforce rights under it if they are specifically conferred those rights. So that means they don't need to be a signatory. So we will qualify that clause 17 to say that it doesn't apply in respect of the bus station improvement works where TfL will have rights to enforce, and that will give them a direct right to enforce those obligations, notwithstanding they don't sign the document itself.
And so that would apply in the event that it is a bilateral agreement.
No, it can also do it under unilateral.
Right. Okay. That should suffice. We'd rather prefer the obligation being made direct to us, but third-party enforcement rights would enable us to enforce in the event of default.
Okay, thank you. Are there any other points anybody wants to raise? I'll take that as a no. So I'm going to pause there for 20 minutes and then we'll reconvene and discuss conditions after that. Okay, thank you. Resumed. We're going to discuss planning conditions now. Again, it's on a without prejudice basis for those parties who aren't used to this format. So I've received a copy of the conditions, and that's been revised quite recently. And I received a copy, I believe this morning actually, on the latest conditions. And those are the ones I'm going to be referring to. And I think there's a printed copy of those on my desk.
There is.
Yeah. So I'm going to ask the council to go through the conditions. There is some 72 conditions, I think, or so. So perhaps we could batch those together. I don't want to necessarily go through every condition line by line, and I do acknowledge that inspectors are able to change and alter a condition if they need to, again on a without prejudice basis. So if we could look at those conditions, have an overview of those, why they're required, what they're seeking to do, perhaps in batches of 4, and then I can ask other parties if they've got any comments on those. I think a lot of the conditions are agreed between the council and the appellant, is my understanding. I don't know if the Rule 6 have any views, but please let me know if you do. So yeah, over to the council to introduce the conditions, please.
Thank you. So yes, they are agreed with the appellant. We've got a couple of updates further to the list that you've got in front of you, so I'll flag those as we go through. Conditions 1 and 2, just the standard approved plans for enforceability purposes, and that permission must be implemented within 3 years of the date of having been granted. Then we move on to pre-commencement conditions. We've got a number of, the first one, it relates to the phasing of the development. Phasing is on two broad phases, and the environmental impact assessment was set out on that basis. So that's just to ensure that if there was any significant departure from that, we'd have the opportunity to recheck that those environmental impacts would still be the same, would there be any differences. We have a fairly typical contamination condition, given past uses on the site and the current use as a petrol station on part of the site. Condition 5 relates to schemes of work to improve the exposed flank walls. So there would potentially be 2, the clock tower and the bank building. So following demolition, just to ensure that they're treated appropriately, given that they'd be newly revealed. Condition 6 is about unexploded ordnance, again, given historic events on the site. That's fairly typical. We've got a number of conditions in relation to trees, because we've got policies in our plans about protecting trees and planting new trees. So we've got a number of arboricultural conditions to protect the retained trees and make sure that the proposed trees are delivered. So that takes us up to condition 8, and it also includes sort of long-term management and maintenance of those to ensure that they would thrive. Condition 9 is a construction management plan condition, and this is one which I think the council would be happy if it were reduced slightly. There are a number of bullet points which set out various British standard documents which should be adhered to. I think from the council's perspective, the main one would be our own guidance on construction management plans.
So you were saying that that could be condensed?
It could be condensed, yes, and we can provide you with an update. Yeah. Condition 10, we've revisited this and we don't think that's actually required. That was relating to an overheating strategy, so we would propose to remove that one from the list. We have a number of conditions relating to archaeology, because the site's in an archaeological priority zone, and there would also be a section 106 obligation linked to that. That's linked to policy P23 of the Southwark Plan. Condition 12 is similarly related to archaeology. Condition 15, we've got a number of conditions which have come through from statutory consultees and from our drainage team One is about sustainable drainage across the site. The site's in a critical drainage area, so we'd need to make sure that there were no surface water flooding issues.
Sorry, Vicky, can we go back? I don't know if we're looking at the same version of the condition. Did you say condition 10 was the one that could delete it? Yeah, say that's.
Sorry, it should be condition 14, shouldn't it?
Yeah,
I've given you the wrong number.
Condition 10 was the art. Oh,
okay. Maybe I'm looking at the wrong version.
Oh, sorry. Sorry. I think Vicky's just gone out of order. That's all I was asking.
Yeah, so, apologies. Yeah, I think it is condition 14.
Yeah.
Okay, so can we go back to condition 10 then, Vicky, just so it's clear for the inspector?
Condition 10 is an archaeology condition, and we've amended the wording of that slightly, and we've just added "and mitigation" in there, which is underlined in the version that you have.
Yep.
11 is archaeology. 12, we've spoken about that. That's archaeology as well. Overheating, condition 13. So that's for a noise impact assessment to be submitted in the event that any food and drink uses are opened on the site, just because of the potential for amenity impacts. Condition 14 is the overheating one, which we would like to delete. Condition 15, I've spoken about.
Does the appellant agree with that? Sorry, with condition 14 being deleted?
Yes.
Yeah.
Yeah. Condition 16 is from Thames Water, who are a consultee, about details of any piling to make sure that there would be no damage to underwater infrastructure assets, in accordance with policy S15 of the London Plan. Condition 17 relates to asbestos and has a need for a survey given the age of the existing building. 18 relates to details of green roofs. We have policies in the Southwark Plan about urban greening and biodiversity to make sure that there be an appropriate standard. Condition 19 relates to a study to look into whether there would be any impacts or mitigation required for TV and radio signals, given the number of tall buildings which should be proposed on the site and the fact that it's predominantly a car park and a low-rise shopping centre at the moment. Condition 20 is to control noise from plant to protect the amenity of neighbouring uses. 21 is this is about making sure that there would be no harmful gap in the conservation area following the demolition of the existing building. So we'd like to make sure that the developer is intent on rebuilding as soon as reasonably possible. Ordinarily, we might have said that there would be a valid contract for redevelopment, but that didn't work for Berkeley. So they instead suggested wording that they have to have submitted their Gateway 2 application for fire safety to show that they are going to get on with the rebuilding fairly soon after demolition. 22 sets out all the highway works which would be required alongside the development in order to ensure that the works around the site be suitable, new paving, pavement width, etc. And that comes from our highways team. And the relevant highways policies are listed in the reason.
I noticed some of the repaving specifications, they're asking for Yorkstone and sandstone. Is that tying in with conservation objectives as well?
Yes, it is. Yeah. So then I think we're at condition 23. So these are the above grade conditions, which are all fairly standard, I think. Materials, samples for the new buildings, details of cycle parking to be provided, some additional wind microclimate testing to be done. This was identified through the EIA process, so we've agreed that wording with the appellant. Details of play equipment at condition 26, signage strategy, the digital infrastructure. We have a policy on that in the Southwark Plan. That's to ensure that any ducting is built into the scheme as necessary.
Could I ask about condition 27?
Yep.
Is it also extending to conservation area concerns? Or is this
Well, yes, there would be shop fronts along the conservation area frontage, so that strategy would be triggered for the entire development, including the Rye Lane section.
Okay, thank you.
Condition 29, detailed drawings. I think these are all fairly typical. Condition 30 is for some large-scale mock-ups, so more of a structure for us to go and view on the site because of the size and prominence of some of the proposed buildings. Condition 31 relates to water use.
And before we move on, condition 30, it mentions specific buildings, building M, J, H and L. Is there a reason why other buildings should be mentioned in this?
It's because these are the largest ones on the site, as far as I'm aware, and we have found that we don't ask for these on every block. It's generally where the building would be very large and very prominent, and we want to make sure the details are right. There was some pushback from the developer on this one because of the expense of preparing a mock-up. So we don't apply it throughout a development. We would look specifically to secure that on larger elements of a scheme.
And for the smaller elements, you'd be wanting the specifications of the materials anyway?
Exactly.
Okay.
Yeah. So 31 relates to our policy P69, sustainability standards, water use, reducing water use. Condition 32 is a fairly typical extraction and ventilation condition for any food and drink uses to protect amenity, pursuant to policy P56 of the Southwark Plan. P33, whole life carbon, that's a requirement from the London Plan for monitoring of carbon cycle throughout the development in relation to carbon emissions. Condition 34, secure by design. We have a policy on that in the Southwark Plan, P16, designing out crime. So that would require the developer to submit measures to demonstrate, or certification usually, that they've complied with secure by design standards. 35 is a fairly typical landscaping condition. 36 and 37 relate to biodiversity, bat boxes and the like, following our policies P60 of the Southwark Plan on biodiversity. Extract and ventilation details for the basement car park to ensure that air quality would be suitable for users. Condition 40 relates to servicing and delivery management, and it requires a plan to be submitted for approval. There's been a little bit of back and forth on this one, but we have managed to agree it now. And what we've done, and we'll come on to, we've been talking to TfL about this as well. There are some extra conditions at the end, 71 and 72, I think. So those two conditions deal specifically with the points that TfL asked us about. Uh, 41 and is about level gradients within the building to ensure people can easily access the accessible car parking and cycle parking. 42, that relates to trees, which we've already discussed. 43 is a flood warning and evacuation plan, given the site's in a critical drainage area. 44 is a fairly typical condition about details of all the site boundaries and how they would be treated. We don't have that information at the moment, and there could be some quite important relationships with the surroundings. So we've asked for details of that for approval.
Is that not covered in the landscaping specification?
Let me check. Landscaping. We're just checking it now, but I think if it isn't, we could add it in there and perhaps do away with the boundary treatment condition if that would make it more concise.
Yeah.
Okay. Okay, site boundary. So I got up to 45 is a condition about obscure glazing. There are a number of conditions in relation to obscure glazing, which we could possibly put into one condition, if that would be preferable.
I'd welcome that.
Yeah.
Yes. Yep.
Yeah, and this is owing to close relationships, predominantly within the site. We've spoken about drainage, an external lighting strategy to ensure that there wouldn't be any adverse light pollution impacts, policy P56 of the Southwark Plan. (49) is also about obscure glazing. Condition 50. Condition 50 is about a strategy for the management of the outdoor spaces around the commercial units, potentially spill out space for restaurants, etc., and how that would be managed, given it's going to be potentially a very busy public realm.
Is that a standard condition?
On this type of developments, we do tend to put it on. You know, if this scheme were to go ahead, there would be a lot of footfall. We'd want to make sure that the spill out space was sort of properly managed, but not preclude people from displaying items outside, or having tables and chairs out there. It's just to keep a handle on that, I suppose. 51 is BREEAM, again from policy P69 of the Southwark Plan, which sets out our sustainability standards. 52 is from Thames Water, about ensuring that there's adequate water infrastructure to serve the development. And we have a number of policies relevant to that listed in the reason. 54 is archaeology, we've spoken about. 55 is the updated development in accordance with the fire strategy, given the number of tall buildings, and that's a requirement of policy D12 of the London Plan. Condition 56 seeks to restrict delivery and collection hours to ensure that there would be no loss of amenity to neighbouring properties, and these have been agreed. These have been discussed quite extensively with the appellant. And condition 57 is similar, sets out opening hours for the non-residential uses. And for the communal terrace, 58, so that could potentially be combined as well, if that would be helpful. 59 seeks to ensure that noise levels within the new homes would be acceptable, pursuant to our protection of amenity and high quality homes policies. Condition 60 is similar, to ensure that there wouldn't be any unacceptable noise impacts if a flat is directly above a commercial premises. Condition 61, so that restricts the, or seeks to restrict the appellant's ability to put sort of the old light industrial type uses, class E, G, class EG, I think, along the Rye Lane frontage. Given the importance of that as a shopping street, we felt that that would be better with the lively retail type uses. 62 is, 62, 63 and 64 are all fairly similar in that they relate to putting plant and other equipment on the building that might detract from its character and appearance.
Yeah, just a small point in relation to some of these. It's the gross internal floor area. Sometimes it's abbreviated, sometimes it isn't.
Okay.
As a standout.
Okay. Okay, we can look at that. 65, this just sets the parameters of what has been approved. In the past, that might have been in the description of development, but we routinely now put that as a condition in the event that the developer wanted to change anything in the future. 66, it is a circular economy. This is related to the carbon saving policies in the Southwark Plan and the London Plan. 67 seeks to limit the hours during which the emergency backup generators could be tested, so that it wouldn't cause any noise nuisance to anybody. 68 was a condition that the appellant asked for, that all the dwellings have to comply with or exceed the nationally described space standards. And 69 is for submission of a travel plan, modes of travel. And then we have 3 in bold. So conditions 70 and 71, these have come from TfL. At the moment, servicing vehicles are able to go across the bus station. And that would no longer be necessary if the development were to go ahead. So these 2 conditions would require details of the way in which that would be prevented. So whether there would be a bollard control to ensure that nobody could, servicing vehicles could go across it. And that would be in the interests of highway safety and removing servicing from the bus station.
And TfL are here. Do they have any objections to this approach?
The condition has been worked out in discussion with Southwark and Berkeley Homes to address our concerns about impact on the bus station consequent upon a much larger development. I would ask if it's possible to add into condition 70, when Southwark are approving the details, it specifically states in consultation with TfL. That has been discussed with both the parties, but it was a conversation we had after this listing was produced. The service access currently is, there is a defined access separate from the operational areas of the bus station. It's a sort of shared access road, but the development as it's been designed can be serviced without using that access, and the arrangements for pedestrians, cyclists, bus passengers and bus operations as part of the bus station works have been discussed and the framework principles built up without assuming there is no service access through the bus station.
Would the council or the appellant have any objections to the consultation request from TfL?
No.
As a change? No. No.
And the final condition relates to the mix of retail uses. It restricts drinking establishments and workspace in line with the application details. And it also requires a minimum of 75% of the remaining flexible retail floor space on the site to be in Class E, A to C only. And that's because of the importance of this site in relation to retail within the town centre, the requirements of the site allocation and the requirements of policy P35 to retain retail.
Okay, all understood. Does the Rule 6 party have any comments on these conditions?
Yes, 2 comments, please, sir. On condition 68, that relates to the NDSS, the space standards. If you remember in my proof, paragraph 58 to 59, I flagged that there was basically an oversight. The space standards for a 1-bed, 1-person flat depend on whether it's a shower or bath unit. they were in the layout plans shown to be bath units. So the requirement was 39 square meters instead of 37. The 15 of the one bed, one person flats are in fact 37.1 square meters. So as they appear in the layout plan, they are under the space standard. And taking this condition as a sort of sticking plaster, I imagine what's going to happen is they're going to be delivered exactly the same, but as showers instead of baths. So I think, technically that achieves compliance. But if you're thinking about this from the resident's perspective, they've got exactly the same flat of exactly the same size, and now they don't even have a bath. So for me, it's a kind of reverse engineering that doesn't address the point of the quality and the size. It kind of just almost makes the flat worse in order to achieve technical compliance. So I would like you to just bear that in mind when you review those flats and their size. And finally, on 72, we've already given quite a bit of evidence about how the retail should be calculated within the flexible space. My original point was the deduction of the 320 for the workspace. I'll leave you to decide whether it's appropriate to deduct the 350 for the drinking establishments, whether that would fall within your scope of retail. On the 75% point, I think it's just important to emphasize, I hadn't understood this, it's 75% of the remaining flexible retail. So what you have to do is you take the whole flexible amount, deduct the 320, factor the 350, and then it's 75%. So the total retail you're left with is actually even smaller than 75% on that basis. It's 75% of once you've already deducted stuff.
Yeah, I understand your point. Does the appellant have a view on this?
Yeah, so if I pick up 72, the condition is worded that there's no more than 350 is drinking establishments and no more than 320 of the flexi space is for workspace. That could be anything from 0 to 320 or 350. And so the remaining 75% could be the gross figure, because there could be 0 or there could be up to 670 square meters of those other uses. So it's as read. So what we're trying to do, as discussed with the council, is principally just make sure that there is a substantive amount of, I'm just going to put traditional retail floor space, taking up those retail units. And for the reasons we discussed in my evidence yesterday, we're not hiding from that. We're just making sure we've got the right mix of uses on the side.
I do note the term unless otherwise agreed in writing by the local planning authority as well.
Yeah, I suppose you're right that it would, in theory, allow for even less space to be used as retail.
So
that phrase shouldn't be in the condition in my submission. It's a tailpiece, and you're not supposed to have them.
Unless otherwise.
Yeah,
we can get rid of that.
I agree with that. So it's
we're happy with that.
Midland Co-op is the case. It says you can't do that.
Yeah.
Sir, can we ask my colleague Mark just to confirm this point about the one bed, one person units in the floor space?
Yes, please.
Sorry, so the flats are in compliance with the NDSS standards. This is just to confirm that there was some discrepancy on the drawings. So this just seeks to wrap that up, just to ensure that we are in accordance with the NDSS standards. So as Mr. Holloway says, it's to ensure that those one bedrooms are showers instead of bathtubs.
And the Rule 6 doesn't contest there would be technical compliance.
That's right. I think it goes more to the quality of these units and the living experience for the actual residents, and whether those flats are actually designed as a bath space or a shower space, and the implications that flow from that.
Understand. Thank you. Does anybody want to raise anything else about any of the conditions?
There's just one really boring technical point, sir. Section 100 ZA5 of the Act says we formally need to give you our written agreement to any conditions that are properly considered pre-commencement conditions.
Yes.
So we've drafted that. I've signed it. We can either hand it in now or on the 17th. I don't mind, but just so we don't forget it.
Absolutely. And yes, if it could be submitted electronically, that would be the best thing my side.
Thank you very much, sir.
I think that concludes everything, unless anybody else wants to raise anything else.
So can I just pick up? I know there've been some discussions about changes to the unilateral and potential conversion to bilateral and so on. Just before we adjourn until closings, could we just have the timetable for that perhaps summarised? I think it's, as I understand it, it's with the documents with the appellant to pick up the comments from today, and then it's going to be passed back to us.
Yes, that's right, sir. So I had a quick chat with Mr. On after the morning session, and we have provisionally agreed to get you a completed, a finalised version of what will hopefully be a bilateral agreement by Friday next week. That may not be executed by everybody because we've just got to negotiate those points we discussed this morning. We've agreed a timetable between ourselves to do that process. So as I say, hoping to have a final version of the document to you by Friday, and then we'll advise in submissions to you then as to timetable for execution, if that's okay.
Yes, that's all acceptable my side. Yep. So I'm going to adjourn that, and we'll reconvene on the 17th at 10 a.m. virtually. Thank you. Thank you.